Welcome to this first appearance session. This information and planning session will last about 45 minutes. Everyone involved with a divorce case or a parenting case, everyone with minor children, is required to attend this session. And I am sure your feelings about why you're here, as well as the other people involved, are complicated. We recognize that this may be a difficult time for you, and it's our hope that we can answer some of your general questions and help you to better understand the process and your role within it.
The family division was established, in part, to help reduce the adversarial nature of family proceedings and to help you focus on your children. So, with that in mind, we have 3 goals for today's session. First, we'll talk about the court process ahead, including how you might create a parenting plan. Second, we'll talk about the options to concluding your case so you can resolve issues related to your children in a less adversarial way. And third, we'll give you the date for your next event or hearing.
We'll start with a quick overview of the court process. You may have some ideas about the process from outside sources such as television. I commit to you that we will try to keep this as dignified, civil, and child-oriented as we possibly can, and to resolve your case in the manner that works best for you and your circumstance. Please take a look at the chart you were given when you walked in. This will guide you through the process we're about to discuss. You'll note that a trial is the final way to resolve your case. We'll likely ask you to try some other methods first.
First, a petition is filed. This is how any case is opened in court. Next, you will attend the Child Impact Program. Although your relationship may be ending, your roles as parents to your children continue. As soon as possible after your case is opened, you are required to attend a 4-hour educational program to learn more about the impact of separation and divorce on children and how this impact may be managed. As you can see from the list in your materials, programs are available throughout the state, and you can take the course anywhere. If you have not already signed up to take this course, you should do so before leaving here today. You can sign up by calling the program directly, or for most, you can go online and register. All the programs accept credit cards.
The first appearance session is today. Next, to complete your case, the court needs a few things from you. The checklist is on the bottom of the chart. Identify your particular situation, either a divorce or parenting case, and the materials we need are in your packet. For each, you will need a financial affidavit. This gives the court on the other side information about income, assets, and debts necessary to make decisions about how to divide property, debt, and child support responsibilities. This is a document you must swear or affirm to be correct, so please be truthful. You also need to give this document and any other financial or health insurance information to the other side. These must be completed before every event you have here. If you would like some assistance with this document, talk to your case manager.
A vital statistics form gives the court information about who is involved in the case. It must be typed, either by computer or typewriter, rather than handwritten. The parenting plan helps you decide how you will raise your children, even if you are no longer living together. You will see that we don't talk about custody. Instead, we talk about parenting rights and responsibilities. One parent is not awarded a child and the other granted visitation rights. You both have rights and responsibilities in caring for and raising your children, even if it is no longer under one roof. Although this document is long, it gives you a sense of the many parenting decisions needing to be made.
Child Support Guidelines Worksheet and Uniform Support Order. A child support order is calculated to your specific situation and income and is in no way an arbitrary amount. If child support is to be paid, the sooner a child support order is entered by agreement or otherwise, the better it is for all involved, particularly for the parent order to pay support. It is better to establish an order promptly so that a large child support debt does not build up. The Uniform Support Order records the child support amount as well as any alimony amount. Finally, you need to complete either a divorce or a parenting decree. This is the final document that becomes a court order. You complete it as a summary of the decisions made, including financial decisions.
You may feel overwhelmed by the amount of paper. There are a few ways you can get this paperwork done. At the end of this session, the case manager will meet with you each individually to hear more about your situation. Then the case manager will work with you to determine a date for your next event. These events could be mediation, case manager conference, or a court hearing.
Absent a reason not to, you will go to mediation. First, mediation is a confidential conversation between you, the other side, and a professional certified court-contracted mediator. This mediator helps you talk to one another about areas and differences. The mediator is neutral, so does not have a stake in who gets what, and instead helps you make decisions for yourselves. Mediation can be scheduled within 30 days of today and is low or no cost, depending on your income. The case manager will help you determine the cost for your situation. You can spend up to 4 hours with a mediator in 2 separate 2-hour sessions. You are not required to present evidence in a formal way at these sessions, and you're not required to bring an attorney unless you want to. If you come to an agreement in mediation, it will likely be approved by your judge, and you may not need to return to court or ever see the judge.
Not everyone should go through a process where you are negotiating with each other. Mediation may not be appropriate if you have concerns about safety or have experienced violence, coercion, or abuse in your relationship and do not want to meet with the other person. If these or other concerns are present, you're encouraged to let the case manager know. You can either make a plan for mediation to occur in separate rooms, and if you wish, with a confidential crisis center advocate present. Or you can request a temporary hearing with the judge. If you and the other person review the documents in your packet and agree on everything, then a case management conference might be the most appropriate for you. Case managers are not mediators, and they cannot give you advice about what you should do, but they can help you complete your documents if you already agree. However, if you have any areas of disagreement, you should choose one of the other options instead of a case manager conference.
If you have a concern about your safety or need an emergency issue decided on by a judge, please let the case manager know. You may be scheduled for a temporary hearing. You can still request mediation or case management conference following this hearing. If these processes do not result in an agreement, you can choose to either proceed with court hearings or try neutral case evaluation with a judge who is not the judge in your case. She or he will offer an opinion about what your trial judge might decide if your case goes to a final hearing. If you need a final hearing, it may be a few hours to a few days in length, depending on the issues in dispute. Depending on how much time you think you need and how much time there is available on the court's schedule, these hearings may be scheduled a few months to a year out. If, after all of that, you are not satisfied with the results of your case, you have the option of appealing to New Hampshire Supreme Court.
We often receive questions asking if a lawyer is necessary. The court strongly encourages you to seek legal representation at any time. However, the court is also able to assist you without an attorney and is dedicated to treating you with dignity and respect.
Even if you don't have a lawyer now, in mediation, the mediator will encourage you to speak with a lawyer before you sign any agreements. You may not know that lawyers are allowed to represent a client for all or just part of a legal case. This is called limited representation or unbundled legal services. If you are interested in hiring an attorney for just part of your case, we have a list of attorneys willing to provide this service available today when you talk with the case manager.
If you don't think you can afford a lawyer, even for part of your case, you might qualify for a free or reduced fee attorney through the New Hampshire Bar Association. Ask the case manager for contact information for those programs.
A few reminders. Unfortunately, we do not have childcare in the courts, so please make other arrangements for your children. Please do not bring firearms or other deadly weapons into the courts. If you need an interpreter for any process, including mediation, please let the case manager know. The case manager will now meet with each of you individually to talk through any questions you have and schedule you for your next court event. Best to you all.